Welcome to today's town hall. I'm Shannon McCracken, CEO of the Nonprofit Alliance. The Nonprofit Alliance was founded for and by organizations on both sides of the political and ideological aisle, as well as many organizations that are decidedly nonpartisan. We share common issues and interests, and it's in that shared space that TNPA works, as our mission statement says, to protect, promote, and strengthen the philanthropic sector in the best interests of our donors and our beneficiaries. We have excellent turnout today, very high registration numbers, and appreciate each of you for being here to learn more about this issue, to ask questions, and to consider the importance of each signature on this Amicus brief. It is thanks to our members, both nonprofit and related service providers, that we are able to undertake this effort. This is an open town hall today for members and our broader shared community, and the Amicus brief is open for the benefit of us all. All nonprofit organizations are invited and encouraged to sign. To our current members, thank you. To those now considering membership, imagine how much more we will do with your sustained participation. In a moment, I will turn this over to the attorneys to walk us through the case. We originally structured this as a Zoom meeting with the ability of everyone to participate, to control your mics and your cameras. Because of the number of participants, we needed this morning to convert this instead to a webinar format with lines muted, but we do not want that to stop you from asking questions. Please use the Q&A function at the toolbar at the bottom of your screen to drop in your questions. TNPA staff will monitor to either respond directly or to share out to our two speakers. Any questions clarifying a point or asking us to go back and repeat, we will try to surface as soon as we see them. Other questions we may save and address at the end. You can also opt to use the toolbar at the bottom to raise your hand, or alternatively send a chat message to Abby Graff, TNPA staff member and the meeting host, if you would prefer to be unmuted to contribute to the conversation. Let's move on to introductions. My colleague Bob Tigner is General Counsel for the Nonprofit Alliance. Some of you know him as the longstanding Executive Director of the Association of Direct Response Fundraising Council, or ADRFCO. Bob has been working all the front lines on this initiative in conversations with some of you and also with our Charitable Giving Coalition members and other concerned parties. Karen Donnelly is partner with Koplowitz, Lamb & Rainey, a law practice that is well known for its work on behalf of tax-exempt organizations, charitable fundraising, and First Amendment rights, including arguing 2 successful cases in front of the U.S. Supreme Court. Both of those cases secured important rights for all charitable and fundraising organizations. Karen is exceptionally qualified to write the Amicus brief, and Karen, we thank you for your considerable work on this and for joining us here today. We have quite a mix of attendees and represented organizations today, with some of you with law degrees, some attorneys, many of us are not. Karen's going to thread the needle on sharing information that will help all of us leave the call today understanding the issue and the purpose of the brief. And Karen, with that, I turn this over to you and to Bob.
Thank you, Shannon. Bob, should I go ahead and start?
Please do, after you, Karen.
Okay. I'm going to go ahead and present kind of a 30,000-foot view of where we are today, why we're here today, and the background of these cases. On January 8th of this year, the United States Supreme Court granted certiorari in several critical donor privacy cases: Americans for Prosperity versus Becerra and Thomas More Law Center versus Becerra. This means the court will hear these consolidated cases on the merits, and all amicus briefs are due on March 1. We have the unique opportunity here to draft and file a brief. And I'll take a moment quickly to explain what an amicus brief is too. An amicus brief is a friend of the court brief, meaning that the filer and any co-signers are not parties to the case. We are friends of the court, friends of the justices, to tell them our position on the issues and provide our perspective, in this case, a very unique perspective on industry. The Supreme Court has long welcomed amicus briefs and has placed high value, in fact, on briefs from industry. There are ample articles out there to attest to that. Industry can present the issues in a way that a lot of the other filers at the certiorari level and probably at the merits level as well will not be able to do, and that we can present our perspective in terms of how important these issues are in our sector, in our ability to fundraise, in our ability to keep our donors giving and certainly happy and willing to give more. But most importantly, the Supreme Court has placed tremendous value on industry briefs and their ability to convey real world effects, real world harms that the issues present to all the signers and those they represent. So this brief would be as Shannon said, a nonpartisan representation of the entire nonprofit sector and the nonprofit fundraising industry. So having provided a little background as to the brief itself and its role, I want to talk a little bit more about the cases and their background. These cases challenge the California Attorney General's practice of compelling disclosure of 501c3 organizations' major donors. They're currently doing this by requiring a copy of Schedule B, which is a part of the IRS Form 990 listing major donors who contribute more than $5,000. This is protected from disclosure by federal tax law, by First Amendment, and by an important case, NAACP v. Alabama and its progeny. So these cases started a little shortly after the practice of compelling the major donor lists started in California. I believe that practice started about 2014. These cases were filed in 2015 and started in district court, consolidated at the Ninth Circuit. They kind of went up and down a little bit and ultimately ended up with a reversal at the Ninth Circuit, which we are hoping to reverse here before the High Court. In the district court, procedurally, the district court in Thomas More Law Center determined not to grant or deny cross motions for summary judgment. Essentially he denied both cross motions and wanted to see a full bench trial in that case. The same happened in Americans for Prosperity. So we've had two interesting opportunities here to have a full bench trial where we end up with a lot more evidence than we otherwise would potentially at a summary judgment stage. So during those bench trials, the district court learned of not only numerous and regular inadvertent disclosures of confidential donor information by the Attorney General's office, but also a number of admissions that they didn't even need the information collected for the purported purposes stated. 1,800 cases or instances, I should say, were identified in which the California Attorney General's office mislabeled Schedule Bs and posted them on its website for the public to see. That's almost 2,000 instances of disregarding donor privacy. In addition, a number of staff of the AG's office testified and admitted that they simply haven't used these Schedule Bs for the purported purposes of investigating fraud. In addition, if the charitable regulator, in this case the Attorney General, is interested in investigating fraud, there are additional means the court identified, more narrowly tailored means to go about that, such as issuing subpoenas and potential other ways that will comply with due process. So we have a number of what the court called certainly a substantial record of the inability to protect donor privacy and this confidential donor information. And unfortunately, at the Ninth Circuit level, the Ninth Circuit disregarded all of those facts. And really what it comes down to from a constitutional perspective, a First Amendment perspective, is they applied the wrong standard of scrutiny in that they determined the regulation, in this case, the compelled disclosure of the major donors, did not need to be narrowly tailored to any compelling or even substantial interest that the state may have in collecting that information. So without the narrowly tailored prong being adhered to by the court here, or the Ninth Circuit, it creates tremendous leeway for Attorney General's offices and charitable regulators across the country to exceed the bounds of the law to request or demand information that is confidential, private, and to which they're not entitled. And information is protected, as I said, under NAACP v. Alabama, First Amendment rights to freedom of speech and association. And in this particular case, in Schedule B, is involved under federal tax law. But it is important to note, and I want to take this opportunity to say this case is about more than just Schedule B. It's about donor privacy. And we need to keep that in mind, and we will certainly make that clear in our brief, because creating this door, opening the floodgates to state charitable regulators to require not only major donors, but whatever else they may want, without proper checks from industry, lends to an enormous list of potential harms. And those harms include, but are not limited to, inadvertent disclosure. In fact, the district court explained inadvertent disclosure is not only possible, but likely, given the substantial record of failure to protect this confidential information found in these two particular cases. So these risks include inadvertent disclosure, also advertent disclosure, and not just to the public, but to media, reluctance to give, individual donors who want to remain private for a variety of reasons, that may include family, religion, and just privacy, may not be willing to give if an organization is soliciting in California and there is some risk that their name could be exposed, not only their name, their address, and the contribution could be exposed on California's website. And it's not limited to California either. Two other states have already followed suit. New Jersey and New York are currently requiring organizations, nonprofit organizations, to produce their major donor lists. And New Jersey, in fact, is requiring it not only of C3 organizations, but also C4 organizations. Even though the IRS no longer requires Schedule B or a major donor list from C4s. So we have also a somewhat unusual situation here where we have 14 states that filed an amicus brief at the certiorari stage, really affirming what the the California AG's office testified to in the Thomas More case at the district court, which is, you don't need this information to do our jobs. You don't need this information to register nonprofit organizations to solicit charitable contributions. Out of those 14 states, 12 of them do regulate charitable solicitation and require registrations of nonprofit organizations. In addition, we have a brief by the federal government also in favor of the petitioner's position. So we have a showing of overwhelming support, and I would say all, certainly the majority, but I would say all of these briefs really focus on the First Amendment issues. They're critical, freedom of speech and freedom of association. But what hasn't really been done at all is the industry perspective. And that's where we can come in and talk about what are, all of the basic facts of our industry in terms of some of the numbers and statistics to introduce us, explain the history of charitable solicitation regulation to some extent to set that up. We will touch on the First Amendment because we have to the extent that this is a highly regulated speech activity and it implicates the right to associate anonymously as well. But we'll be able to go really in depth into the potential effects of this regulation and other regulations that would likely follow suit, or almost certainly would follow suit by other states, and how this would open the floodgates for those additional overreaching opportunities by state governments here. So other harms that could be an issue here include, as I said, reluctance to give, but also potential pirating of donor lists and simply, organizations not wanting to even fundraise in California or New York or New Jersey for these reasons. And these are large states with a lot of potential donors. So that's not really an option for most organizations, but it's certainly not the correct alternative under these circumstances constitutionally. So that's a little bit on some of the harms that we're going to address. I can talk a little bit more about some of these other details. Bob, do you want to chime in at any point, or should I keep going with some of the background? Or
well, I would like to add a footnote.
Sure.
While there's ample evidence in these cases of inadvertent, in quotes, misuse of the Schedule B information by making public, there's no evidence in these cases of intentional misuse of the information by the California Attorney General's office. But, and this is a big but, why do they want the information? And I think it's important to be mindful that attorneys general are in almost every state as an elective political office. And politicians are not immune from using the power of their office in political fashion. And while the California AG's office in an immediate sense has not misused donor information, AGs in other jurisdictions have certainly gone after nonprofits for political reasons. And so that strikes me as another considerable danger in having this sensitive information in the hands of state officials, offices.
Absolutely. And as NAACP v. Alabama made clear, the disclosure of donor names to a political office of attorney general or other appropriate state regulator increases the risk of abuse of enforcement power, which could be just as devastating, as you said, as that office's inadvertent leak, which has been demonstrated, of the confidential information to the media or the public. So that risk is incredible and very real here. And to talk a minute about the NAACP v. Alabama case, which is the seminal case, and often considered in a lot of the amicus briefs that were filed at the certiorari stage as this line of cases that recognizes the proper level of First Amendment scrutiny that should be applied here. And that's because in the mid to late 1950s, the Attorney General of the state of Alabama tried to run the NAACP out of the state. In so doing, they tried to compel disclosure of their major donors so that they could, well, all of their donors, so they could go after their supporters. And it really threatened, a number of terrible, I mean, we all know, that era and all of the things that would have and did actually follow suit there. So that case really demonstrates that you need more than proof of just threat of reprisal or harassment in order to be free from these compelled disclosure requirements on an individual basis, but you need the opportunity to make a facial challenge that compelling this information is not good, not just for us as this particular organization, but for all organizations, all nonprofits within the sector. And that's really the procedural posture we find ourselves in under the current Ninth Circuit precedent. And that's if we are not able to prevail in improving likelihood of harm in terms of threats and actual harassment for our particular organization, then we'll be denied an as applied challenge, and our opportunity for challenge therefore is done, and we have to comply with the rule unless this is reversed, of course, at the Supreme Court. The Ninth Circuit, in an earlier case in Competitive Enterprise Institute, determined that the facial challenge was inappropriate in that case. So that precedent, the Ninth Circuit, in its later hearing of the Thomas More and Americans for Prosperity cases, determined that previous decision bound the Ninth Circuit, and they couldn't hear the facial challenge at that later time. And likely certainly the district court felt the same. Under stare decisis, even bad precedent is precedent. So what we're hoping the Supreme Court does here is reverse the Ninth Circuit's ruling on the facial challenge so that it's not putting nonprofit organizations in a position to have to litigate and prove individual threats of harassment or reprisal in order to free themselves of the requirement, because if they can't do that, then their alternative is to comply, and then they're in a position to either respect or honor the donor's wishes to remain anonymous or to comply with the unconstitutional compelled disclosure requirement. So what we're hoping for is a facial challenge and an opportunity to get the Ninth Circuit's decision reversed, to acknowledge the correct level of First Amendment scrutiny here, and to really take this opportunity to present the industry perspective and how devastating this could be for nonprofit fundraising from the harms that I mentioned, as well as a significant harm that Bob alluded to earlier as well. So this is such an important case in that it destroys donor anonymity, and it creates an opportunity for states to abuse potentially confidential non-public information. And it opens the door to more overreaching by state charity officials who will, if not challenged, continue to exceed those bounds of the law that permits them to demand information from registrants. So the adverse effects if California wins this case will potentially be devastating. So this is an opportunity that I think is critical for the nonprofit sector to come together and to really share, the effects to industry, but also the perspective of a little bit of the history of regulation as well, rather than just strictly the First Amendment arguments, which have been discussed at length and duplicated to a great extent, I think, thus far. So our brief would not be duplicating existing briefs. It would be offering a unique perspective. So that's kind of where I am on my overview. And then I have some more detailed items, but I want to check in with Bob to see if he wants to add anything before I kind of get into some more of the nuance.
Just another PS, and I won't take too much time with this, but most of you in the audience who are running nonprofits know what the literal out-of-pocket costs are for complying with charitable solicitation laws in 40 states, 39. There are probably a third or so of those states that are fairly aggressive regulators of charitable solicitation. And they push the boundaries. And they often push those boundaries with respect to individual nonprofits who are then put to the task of either paying to defend themselves and pushing back on those boundaries, or compelling. And the logical thing to do on a cost-benefit basis almost always is complying with those requests or those demands. In this case, we have the opportunity as a community to push back. Every outward thrust that isn't pushed back costs us all money, year in, year out, in the aggregate in the millions of dollars. So part of this task is not just donor privacy, but doing that pushback against regulator overreach.
We have, before you get into more of the nuances, Karen and Bob, we do have a couple questions that have come in that we can catch up on. One of them is, I'm reading it, you mentioned that certain states are already sharing information. Can you please name them? California, New York, New Jersey. So those are the 3 states that are looking to have the Schedule Bs included in filings, not intentionally sharing. Anything you want to clarify there?
Yes, so there was a separate Second Circuit case that did not have, I don't believe that one had a bench trial in the level of detailed record that these cases had in California. But the 3 states that are requiring disclosure of major donors are California, New Jersey, and New York. And the state that we're discussing today in terms of the demonstrable failures to protect privacy and the inadvertent disclosures and admissions that they weren't actually using them for the purported purpose are all limited to California.
Thank you. And for further clarification, all C3s, when they file their 990s, are including Schedule B. Schedule B is redacted from public sharing and is not normally included, although 990s are included with state filings. Schedule B is not, historically has not been included with that. So, and the additional distinction I heard you make, Karen, is that New Jersey is also now requiring Schedule B or equivalent from C4s, which are not required to file that with the IRS.
That's correct. So the IRS requires C3s to file Schedule B with the IRS, but the IRS has a number of very, very strict provisions that keep that information confidential and actual penalties, criminal and civil, for disclosure of that confidential private information. So it is an entirely different level of respect for that confidential information at the federal level than what we're seeing at the state level. So California is currently requiring that donor information and currently in the form of the Schedule B from C3s. as is New York. New Jersey is requiring it from both C3s and C4s, and you are correct, C4s are no longer required to file major donor list with the IRS.
There's a question about, will there be a chance to read the brief before signing? I know you're going to be talking to the timeline a bit later in the call, but we do just want to acknowledge, yes, the brief will be available before signing.
We will, to be clear, we'll have a draft of the brief probably, Karen, by the end of next week?
Absolutely, next week, yes.
Okay. And so at that point, people interested in signing, if they've indicated to us, we'll get a copy of that draft, and you can be assured that the final will not vary in any significant degree from that.
Absolutely. We're creating a list, a circulation list. So Bob, if they're interested in receiving a copy, would they then sign on the website or notify you? And they could also notify me as well. We're managing a list, but.
And we're managing a list as well. So an email to me with contact information, and you'll get added to the list for the draft brief when it's available.
And by default, everybody who's registered today will also receive a copy. So if you're on the call today, you don't need to add to that. One additional really good question, Karen, is there an industry sector that supports the regulations? Why wouldn't we support? What's the counter argument?
So I need to repeat the last bit of that, sorry.
Sure, yes. So is there an industry sector that supports the regulations or supports the case? Why wouldn't we support? What's the counter argument to your points today?
Not in our industry that I know of.
None. And that's why we wanted to make this clearly a nonpartisan brief. But I think if you look at organizations that are typically associated in terms of ideological issues or advocacy with one side of the aisle or the other, that you'll see all of the folks weighing in some capacity and representation in amicus briefs here. So it is a really large representation of the sector, but what we haven't seen yet is the actual industry perspective of the harms and effects of this regulation on charitable fundraising, nonprofit fundraising moving forward. So that's our perspective. But there really are no counter arguments. I mean, when you have 14 states, 12 of which regulate charitable solicitation, and the federal government all weighing in favor of the nonprofit petitioner's position, that's a really strong showing of support for this sector and really important. And it's a critical opportunity for all of us who are interested in signing on to take that moment to advocate in support of the nonprofit petitioners who have had the long struggle. Litigation is expensive and long, and they've been fighting this battle for 6 years, and it has been a long and brutal battle. And they have, because these particular organizations do touch on issues that are often passionate to some people, they are actually experiencing these threats of reprisal and harassment that not all organizations will feel. But that doesn't mean that you shouldn't sign on or consider signing on, because I think the core issues that we're able to raise here are, as Bob said earlier, the potential for state charitable regulators to request major donors not only in Schedule B form, but in other forms, and then to expand what they're demanding beyond the bounds of the law with very little checks, because if not reversed, that gives way too much leeway and little accountability really for their actions for those that are speaking in this highly regulated speech area. So.
And one more question, that's a clarifying question that's come in. So is it just government AGs who, government and AGs who want it and say that they need it? Is that really what we're looking at here?
Yes. So I don't know how much detail I should go into in terms of regulation of nonprofit fundraising here, but over 40 states require nonprofit organizations to register before they solicit funds. So when I say state charity regulator, I mean either the Attorney General. It varies by state who the state charity regulator is. For example, California, it is the Attorney General's office. Here in Missouri, it's the Attorney General's office. In some states, it's the Department of Justice. In other states, it's Department of Agriculture. In other states, it's Secretary of State. It's a very common executive agency that handles this process of registration. So More generally, it is state charitable regulators, but yes, it is state governments that we're dealing with here. We haven't seen this much in the local level. As I said, from that NAACP v. Alabama case, we have a long line of cases that followed throughout the 50s, 60s, and currently today, and we've cited to a number of them over the years in our briefs, in that they looked at, for example, NAACP v. Alabama looked at driving the NAACP entirely out of the state by going after their major donors. Well, NAACP v. Button, several years later, looked at Virginia's approach to trying to force NAACP out of its state, or Commonwealth, I should say, by changing the legal ethics rules to discourage attorneys from trying to motivate plaintiffs to challenge segregation or efforts to continue segregation after Brown v. Board of Education 2. So you'll see that it's not just, that's why we call this an issue of real donor privacy, not just Schedule B, because the demand for the confidential information is not limited to that Schedule B. I mean, that does help us here because we have strong tax law protecting its disclosure as well, but it's the idea that they're demanding this confidential donor information and disregarding donor privacy entirely. And then from there, where will they go? And how much more will be demanded in other areas, and how they can do this in different ways. So that's a major concern.
We do have another question that's come in, but I think it's one that we're going to hit on in terms of the process of signing the brief. So Karen, I'm going to duck back out and let you continue with additional information. We'll come back to some of the how to sign and when to sign details a bit later.
Okay. So I might start to kind of move in that direction. I just wanted to cover a couple of the nuanced details here. As part of filing an amicus brief, we will be filing, I should say at the beginning, a booklet form that is required by the Supreme Court. So we'll be sending our draft to the printer a few days in advance of the 1st of March to make sure that we get it typeset and printed correctly in the required format. In the process of getting this drafted and printed, we also need to make sure we notify and obtain consent from all parties in the case, and we have already done that. We have notified and obtained consent from the DOJ in California, so the Attorney General's Office of California, as well as counsel for both of the parties in this consolidated case. So we already have consent and notice checked off our list. And I did want to reiterate too that I know I'm just trying to go through some of the questions that I've had too from other folks that might be anticipated today. And one of those was, will there be any duplication here? And we will have to touch on the First Amendment to some degree. And we have to set this up in context, but our purpose here isn't to argue at length those particular constitutional issues, as that is being done and done very well by a number of other amici. Our position is to present all of this in context of highly regulated speech activity that is fully protected by the First Amendment. Excuse me, battling a little bit of cold, so excuse me. And to really discuss these real world effects that the nonprofit sector will face and the fundraising industry will certainly have to overcome. So other folks, I think, have asked if you don't have any anonymous donors or donors wishing to remain anonymous right now, should you consider filing and joining this effort? And I would say absolutely, because if you don't have any donors that have requested anonymity yet, you may in the future. And there's two really answers to this. One is principled, and the other is one that Bob alluded to earlier, and that if you do in the future have donors that want to protect their anonymity, you're put in that difficult position of having to either honor their intention or comply with the compelled disclosure requirement. And as Shannon mentioned earlier, it's always easier and less certainly cost efficient to comply, but it does put you in a very, very difficult position, a very difficult Hobson's choice there. And so your options are to go through if you don't want to produce these donors or whatever other mandatory requirement that exceeds the bounds of the law that could follow in the future, you're forced to litigate, which is expensive, long, and drawn out. And as I said, these organizations have been engaging in this battle for 6 years or more at this point, to try and free yourself of that requirement. Under the current Ninth Circuit precedent, which we're hoping to overturn, that challenge is limited to you individually. So it's certainly a principled position to get behind here. And in addition, if not reversed, as Bob mentioned earlier, more states are going to follow suit. As we've said, two states already have. New Jersey and New York are requiring disclosure of major donors. And more states gathering this information dramatically increases the risk of loss of privacy. So I've really kind of covered a lot of those harms, but the real risk here is that we're going to see this repeat and expand if we don't do something about it. And this is the highest level of discourse in the country to talk about these issues. So I don't think there should be any fear, if you've ever had any issues with California in the past or other states, that should hold you back from signing on if you care about these issues and want to lend your name as a signer to a brief. We're before the U.S. Supreme Court, and that is upper echelon. That is the highest level of discourse on these very important issues facing the sector. So I see a number of questions, but I'm going to keep going, and then I can answer, unless Shannon comes back in, I can answer all these questions at the end. In terms of timeline, we will be releasing circulating, I should say, a draft next week. We're compiling a list here, and Bob's team's compiling a list there, and so we're going to make sure that everyone on those lists gets a copy of the brief. And if after review, you and your leadership or general counsel determine that you are interested in signing on, TMPA does have an Amicus page, on Amicus website page, that you can click sign now and be added to the signer list. And so at this point, we're looking at probably at the close of business of the 22nd of February for those final determinations of whether to sign. But if we have any more leeway on that, we will be sure to let everybody know. So that's kind of where we're at in terms of the process. And I've explained a little bit already about what a friend of the court is, so you can rest assured that you're a signer and not a party. So if anyone has any more questions on any of those things, or I know there's a number of questions in the chat, I can start answering those.
I'll start pulling up some of those questions, Karen. A couple questions about the two organizations that are included in the Supreme Court case. You've mentioned NAACP a number of times and the historic information with them, but clarifying the two that are in the cases.
Just by name, I think, Karen, first.
The two NAACP cases I mentioned?
No,
I'm sorry,
no, the names, the current
NAACP
litigants.
caught that, but the two litigants for the Supreme Court cases now. So AFP and Thomas More. Correct. So there's some questions. If you can just repeat who those organizations are.
Sorry.
Yeah, yes. And maybe touch again on the fact that very often these cases will like NAACP or like Thomas More Law Center, that they're going to be ones that tend to be further out on either side of the political spectrum, simply because that's where the AGs and the government regulators are looking more.
Right. So the two plaintiffs, now appellants, we call them petitioners as well because they petitioned for certiorari for the United States Supreme Court, are Americans for Prosperity and Thomas More Law Center. And in both of their certiorari petitions, they made clear that they are organizations, and some of you may know them. They are organizations that advocate issues that are ideologically typically associated more with the conservative side than perhaps the liberal side. But importantly, Thomas More Law Center did mention that Planned Parenthood, which is another organization that advocates issues ideologically charged per se, that is more often associated with the left or the more liberal side, was one of the organizations that suffered a breach of its information by the California Attorney General. So to that point, all organizations are affected, and the First Amendment protects everyone's right to speak. It doesn't matter which side of the aisle you may be on, or whether the issues that you advocate are typically associated with conservative issues or liberal issues, but that everyone is equally entitled to speak freely and associate anonymously. And that's why this case is really, for a First Amendment lawyer like myself, a beautiful case, in that it is drawing support from organizations across the spectrum in terms of ideological issues, right? And so, you know, in a perfect world, I'd love to see groups that are typically considered far left as well as far right on the same brief, knowing we're all coming together on the same goal here. And that's to show that the First Amendment protects our right to speak and associate anonymously and freely, without fear of reprisal or harm, and shouldn't have to prove those individually in order to free ourselves of those requirements. Did I do okay there in terms of kind of capturing some of that?
I
Bob,
believe
do you
you
want to
did. And
jump
if
in?
anyone has, yes, if anyone has follow-up or needs more clarification, please drop it in the Q&A or the chat. Karen, another one to clarify again. So if you're filing, let's say you're filing in the state of California, are you sharing the donor information only for donors who live in California, or are you sharing your entire Schedule B regardless of where people live?
You're sharing your entire Schedule B. So if you're a donor in Washington, D.C. or Massachusetts, and you donate over $5,000 to either Planned Parenthood or the NRA, and then those organizations are going to have to disclose your contribution on that 990. And California, if they're soliciting there and registering there, would require that information, and has inadvertently disclosed such information, not particular to, well, certainly particular to Planned Parenthood. I don't know if the NRA was a victim of that as well, but certainly has disclosed that kind of private donor information to the public via its website. So yes, it doesn't matter where you are in the country. If you make a donation to an organ, it really affects national organizations or organizations that anticipate to grow to solicit in a number of states at least, including some of these larger states where there's a large number of contributions as everyone competes for a stagnant pool of contributions.
Somewhat related to that, is there any research on reduced giving by major donors if their personal information is required to be provided to state regulators? Do we know actual impact?
I would say quickly that that question is far too narrow to have done any research at this point. I guess there might be some individual nonprofits who would be able to speak to in-house experience. And in fact, there's not a whole lot of academic research. It's scarce on the effects of anonymous giving and losing the right to give anonymously. What little there is suggests that losing that right in certain situations can and will reduce giving, losing the right for anonymity. But as to the specific application of our case, I don't even think anyone has even thought about any research of it, frankly, at this point.
It's a good question, not enough data. Okay, we have a couple questions specific to how to sign the brief, what that entails. There was one question, can you assign anonymously? The answer to that is no, but who can sign, and will the organization be listed by entity? Do you need a CEO officer to sign by name? Are you asking for anything other than the use of the organization's name? And also, can individuals or for-profits in the nonprofit sector sign? So a lot of questions there, but clarifying who the signer would be and what information they're providing.
We're looking for nonprofit organization signers, so it would be the organization's name. We would want something in writing by someone with authority at the organization to let us know, counsel, that you are authorizing our use of your organizational name as a signer on this brief.
Aaron, our protocol for our actual physical sign up has a recitation that the person who transmits the email, which matches the name of the nonprofit organization, claims the authority to sign up for that organization.
Okay, so through this website link, which I understand you provided to all the folks here, is that correct? You have this sign, go ahead. Yeah.
I was just saying, we'll make sure it's in chat.
Okay. You have the opportunity to click sign now, and you'll go through a few steps, including the opportunity to affirm to us that you do have authority to find your organization to list its name on this brief. But that is, in the end, what you are doing is you're listing your organization's name as a supporter of this brief, of a position of industry, reflecting a nonpartisan view of all of the nonprofit industry before the Supreme Court in this case, in support of the petitioners.
And I think I saw another question, and that's the beginning and the end of the obligation. It puts the name of your organization on the brief as, in effect, a co-signer or a co-filer, I guess, for that matter. Co-submitter, whatever the right term is, Karen.
Co-signer, I think, is the one most commonly used by the clerk of the Supreme Court. So that's the one I usually use. But yes, so there are going to be a lot of organizational names here. So we're going to include an appendix that lists all of the organizations that sign on. And I just want to take this opportunity to tell you, I know I mentioned earlier that the Supreme Court does place tremendous value on amicus briefs from industry. And in the Madigan case that my partner Errol Kopovitz argued before the US Supreme Court in 2003, one of the justices during oral argument did pick up an amicus brief from industry and alluded to the harms caused to industry in that case. And so it really is something that is used and adds value beyond duplication of argument that's already there before the court.
I'd like to postscript that one too, Karen. My recollection of the transaction was I forget, the Solicitor General in Illinois or whoever it was, or the Attorney General in Illinois, made the argument that the nonprofit sector at large favored their aggressive hunting of fraud and was behind their prosecution in this case. And I forget which justice it was, then held up the brief and says there's hundreds of nonprofits here that seem to disagree with you.
Yep. So it's a beautiful moment.
And so just to clarify, first of all, although the brief is not yet written, the draft has not yet been released, finalized for review, we do have about 50 organizations that have already signed in principle. We'll review the brief, but that has already been done through a number of those through the link that Abby has just dropped into chat. So you can read some of the additional background there, and then you can pre-sign. We will send you the brief. You have the option, of course, to withdraw if it looks drastically different than what you expected it to look like, but it should not. It's following the talking points on the site and what Karen shared. And just to be clear, when you do sign up through that form, you are entering individual information. So if I were signing on behalf of my organization, I put in my name, my title, my email address, but my name is not going on that. It is the name of my nonprofit organization that will be printed on that brief. Your name is there for us to be able to come back as a point of contact, but it is not what will be shared with the court. Do we want to talk through?
Just confirmed it was Justice Souter for all of you who saw that.
And another question, does the signing nonprofit need to be registered in California? Like, could a local state nonprofit or one that doesn't file in California still sign? So
let me elaborate on that. Not at all. And furthermore, an organization need not necessarily be subject explicitly to any state's solicitation law. The threat to invade a donor file is there for any operating nonprofit soliciting from the public. So, for example, a religious organization could receive a demand from an attorney general to show us your donors, and it would not matter a whit whether or not you were registered in that or any other state. So yes, all nonprofits are welcome regardless of their registration status.
I think that helps PS that a little bit too. I think that goes to the value of the donor list itself, that organizations spend years, decades building, and it is the most valuable asset of a nonprofit organization. And so the interest in protecting that from compelled disclosure and then inadvertent disclosure to the public is, I think, of interest to all nonprofit organizations.
Okay, so can you recap timing? And then we have another question that takes us in a bit of a different direction. So can you recap timing on the brief and what next steps organizations should be taking?
So we're going to release a draft of the brief next week. So we'll circulate that to all folks that have either signed on to the website indicating interest or reached out to any of us here pictured. And so once we release that draft, we're hoping to give you a good week or so to review that and determine if your organization is interested in signing on. From there, at this point, we're looking at the eve of the 22nd, but is really when our request for confirmation is really needed. Do you want to sign on or not, or do you want to withdraw any signature that you previously provided? We will be, at this point, we're planning to send to the printer on the morning of the 23rd. We do have potentially an option to send a little bit later if we determine that we want or need a little bit more time. But in any event, we just, we're looking at about the 23rd, between the 23rd and the 25th to have everything over to the printer and to get printed in order to ship and mail to the Supreme Court. 40 copies have to be sent, hard copy. The electronic filing is more of a courtesy copy in the U.S. Supreme Court, which is a little bit different than other federal courts. So
There's a very interesting question about donor care, I think, and responsibility to your donors. And I should read the question, or does everybody see the question already,
No,
Shannon?
you need to read it out loud.
Okay. Would you advise us to share any of this information with our donors eventually, or is this the responsibility of tax advisors and attorneys who work with those donors that could potentially be affected? I'm not one of those tax attorneys or advisors, but I am a donor. And if I were a donor who, especially one, well, a large donor period, but who would appear on Schedule B, or especially one who had requested anonymity, I would want the nonprofit to which I give let me know about these transactions that they've been forced to comply with. That's just me, but it has to do with care and keeping of your donors, and I think that would be the right thing to do.
I agree on erring on the full side of full disclosure there and keeping them apprised of the situation and of these trends as we see them develop from a policy perspective as well. But yeah, I think it's important to do so. And I know a number of organizations are considering taking the position with the California Attorney General's office that they're not going to provide Schedule B, or they're certainly going to try not to until this case is decided. So there are a number of approaches to handle this with the California Attorney General's office that each organization will have to consider as it considers very important things like donor care and what it wants to do as we move forward. It is likely the court will rule on this by the end of this term in June. And that oral argument would probably be held in April or maybe early May, but there's no guarantee.
I would like to do a PS on my previous observation about taking care of your donors. I assume, but don't know, but I would highly recommend that in case any of you are just sort of in a reactive and pro forma way, sending in your 990s to the states when they are requested, and most of the states who register under solicitation laws require a 990, that you should either not include the Schedule B at all, or you should redact that information. It's a way of protecting their anonymity, and it's an important piece of care for you to take on their behalf.
And one more question has come in, Karen, if you can see that, if the case is overturned, does that mean that New York and New Jersey will have to stop requiring Schedule B?
Yes, and that's another point I wanted to make, but hadn't done so yet. Yes, so if the Supreme Court reverses the Ninth Circuit, then it somewhat depends on whether they do so on a facial challenge or as an applied challenge. But if they overturn them as a facial challenge, which is what we hope they do, then that ruling would abrogate the Second Circuit's ruling, and that means it renders it no longer good law. And I think the important thing here is this case involves a circuit split. So you have the Second and the Ninth Circuit on one side and a handful of other circuits on the other side that would have decided this case very differently. And the Supreme Court's ruling here, which would abrogate the Second Circuit if it rules in terms of a facial challenge, would be binding on all lower courts. So it would make New Jersey and New York have to stop their practice, and it would prevent other states from starting such a practice, and would provide a valuable check to all regulators in this space to not exceed the bounds of the law in that way moving forward. So.
Thank you. So I believe we have covered all of the questions that come in. And again, thank you to everybody participating to be willing to switch it up and use Q&A and chat instead of live conversation with the size of our group today. I appreciate the participation. Bob or Karen, any final thoughts we need to check off on?
No, I would just say this is such an important case to the industry and an important opportunity if your organization wants to come out and support all of industry in its position here. It's just such a wonderful opportunity and an overwhelming showing of support already at the cert stage. There were no briefs filed in favor of the opposition. All briefs, and a large number of them, were filed in support of the nonprofit petitioners. So this is a really important case, and it's very clear the showing of support for the sector already, not only from various advocacy organizations focusing on the First Amendment issues, but also by the state governments and the federal government in this case.
Anyone, please, who's seriously considering or is going to seriously consider signing on to the brief and you have further questions, please get in touch with me at the Alliance. And if I'm unable to answer your questions, I'll get help from Karen. But if you're going to consider, we want to help you get there.
Bob, I'm putting your email address in the chat so everyone has that. It is also on the page on our website, but the links that Abby dropped into chat earlier today as well. Great. Well, we will wrap. Karen, thank you again for the work you are doing to not only write the brief, but also to be here today. And we know you're fielding a lot of questions as well as gathering support for this. So we appreciate everything you are doing alongside the Nonprofit Alliance and so many organizations. Thank you.
Thank you.
And thanks for everyone today. This session was recorded. We'll be sharing out the recording. You have the links, and we will also be following up with you with a draft of the brief when it is ready to share next week.